Hi, good afternoon, everyone. Today is April 21st, 2016. This is a community conference call that we do every other Thursday. My name is Rajiv S. Khanna, acting on behalf of immigration.com, the losses of Rajiv S. Khanna, PC. I'm going to go over, as usual, first the frequently asked questions, which I have marked as frequently asked questions. Then I will go on to the regularly posted questions. And if there is any time remaining, we'll deal with new issues as and when they have come up. That said, let's start with the first frequently asked question. Is H4 visa needed after H4 EAD approval? So the question is this. Uh, my wife has a valid H1B visa stamp till September 2016. This is an H1B, okay? She applied for a change of status. She got her H4 and her EAD. She wants to travel. Uh, First question is, does she need a visa? And the answer is yes, because now she's on H4. So when she wants to come back, she will need to get an H4 visa stamping. Okay. The next question is she eligible for Dropbox facility? Now that is a little difficult for me to answer because you have to look at the local rules on whether Dropbox is permitted to somebody like that. If I remember correctly, I think you have to be asking for the same visa. If you're on H1, you have to be asking for H1 if you want to do the Dropbox. But I could be wrong. I don't remember the rules off the top of my head. But she definitely needs a visa. Last question was, what kind of documents are required for H4 stamping? I would strongly recommend you read the recommendations of the consulate where you're going to go. The consulate will have online information on what you need to bring with you if you want to go for H4 visa stamping. Typically, there's proof of marriage, there is a H1 approval, and a copy is usually enough. But each consulate is different, and sometimes consulates can be very unreasonable. They actually go right into the merits of the H1 itself while adjudicating an H4. So that I do not know what they will require, but normally proof of your marriage and proof of the H1 status is all that is needed. Anybody has any questions or comments about this particular issue? Press *5 on your phone. No new questions, please. *5. Okay. Oh, there is one. Let's take that. Let's see. This is New Jersey. New Jersey, go ahead, please. You have a question?
Yeah, thanks, Rajiv, for the community service.
Of course.
Yeah, I have follow-up questions on that. Does she go for a biometric test as well? Reason is she already went for the stamping, a year back.
Biometrics for what? For the visa or for the EAD?
No, for H1 in India, I'm saying.
Okay, I do not know exactly what the local consular requirements are. I am not involved in that level of detail. Sorry, I can't answer that question for you. Um,
Oh,
but but the thing is, all of this information should be publicly available. So if you just go to the
okay.
consulate website, they should be able to tell you
Mhm.
exactly what she needs to bring, and what kind of process she has to go through. Also remember, counselors are actually pretty good about answering questions too. If you email them something, they do respond. Now, their response may not necessarily be exactly to the question you have asked. Sometimes they respond very oddly, but they do respond. Okay?
Okay. And it's regarding the documents, right? Means my W2s and my pay stubs are required for interview, or
No,
they will look for only relationship only, means
normally,
parental certificate and other things.
normally no, but I have actually known consulates to even ask for end client letters of the H1 holder sometime during the H4 process. Um, a couple of years ago, we actually were invited to give input to some people who were advising the president on the problems that H1 holders and H4 holders were facing. And one of the comments I made in that written response was that uh, consulates can use H-4 visas to hold the family hostage until the H-1 admission is clarified, which is illegal in my opinion. So they can reach as far as they want, but normally they don't require anything beyond um, proof of the marriage and the approval notice. Normally, okay.
Okay. And can she use the same EAD while coming back, which she has at this moment, if she wishes to continue, working?
Definitely. She doesn't need to
Oh,
apply for a new EAD every time she comes back. No, the EAD is good through its entire life.
okay, sure.
All right.
Sounds good to me.
Good luck, sir.
Thank you so much.
My pleasure.
Thank you.
Okay. Let's go on to the next frequently asked question. Now, this is a very interesting issue. H1 cap exempt working concurrently for H1 cap employer. This is a odd little idiosyncrasy or a blip in the law. So if I'm working on a quota exempt H1 and I want to concurrently work for a quota subject employer, I can actually do that by a concurrent H1. So let's say I'm working for a university and at the same time I have a consulting job um, and I want to do that. I don't have to wait for the quota for next year. As long as I hold both jobs, the quota exempt as well as the quota subject job, I can do them both concurrently. The problem is, I think that is the issue here with Peter, that if you want to quit your quota exempt job and go to the quota job, you cannot, not unless you go through the quota process. So let's say uh, last year I started a quota exempt job. Since there is no quota, I don't have to worry about the April-October problem. Middle of last year, I started working with a concurrent H1. Let's say in August or so, I did a concurrent H1. Because it is concurrent with an already existing quota exempt H1, for some odd reason, I don't have to wait for the quota. I can start working right away. Okay. So, okay. So, however, if I want to now quit that job, the quota exempt job, I won't be able to maintain that second H1. That second H1 has to be processed through the April-October quota for it to become a standalone H1. Let me see if that is the question you asked. I think that's what you were asking. I'm currently working on a cap exempt employer expiring June 2017. You have 60 days to join, June to August. Well, so as long as you understand that you will not be able to use the quota subject H1 as a standalone H1 by itself, that's one limitation you have. Can you do an EB2 case? Yeah, I mean, there's no harm in doing an EB2 at the same time. And if you are from a country other than some countries that are backed up, you will be able to get your, if everything goes smoothly, work authorization, etc. But I think this time frame that you're thinking is a little unreasonable. I don't think it's going to work like that. Okay, but one of the main concerns I think you had was, can I do it as a standalone H1? And the answer is no. So anybody who has a follow-up question on this, please press *5. Follow-up question on this, *5. I'm also watching my Twitter account. Okay, so if you are tweeting to me, I can see that as well. All right, let's go on to the next frequently asked question. Safe time to change jobs after I-140 approval. Now, I was discussing this yesterday with somebody and they were confused. Yesterday we did a conference call, kind of an unscheduled conference call for issues related to what is unlawful presence, what is status, what is nunc-pro-tunc approval. I'm going to post that as well. I should have that up this afternoon. So one of the issues raised was on AC-21, and another guy who raised that issue was that um, how safe is it to change jobs? Because if the employer revokes the I-140, does my priority date go away? And I explained to them that USCIS has flip-flopped a lot on these issues. Um, Today's thinking is that if your employer revokes your I-140, you still get to keep your priority date. You don't have the right to extend your H-1, but you can keep your priority date. And then there are regulations pending, which could be enacted anytime, promulgated anytime. Those regulations say that if the I-140 actually stays approved for 180 days, not only do you keep your priority date, you also keep your right to get your H-1 approvals through any employer forever. Okay. So if you can wait 180 days, Sudhirji, you should, because if the regulations kick in, you would have that additional protection. If the regulations don't kick in, at least you would not have lost anything. So that's the way I look at it. That's the practical solution. Um, Anybody has a follow-up question on that, press *5. *5 if you have a follow-up question. Okay, there is one. Illinois, go ahead, Illinois.
Hi, Rajiv. Thanks for the conference call.
Of course.
I'm on like my fifth year of my H1. So if I wanna like change my employer, I have I-140 approved. If I wanna change my employer, and if I go to the new employer, the time will take like more than 1 year, right, to get the new I-140 approved. So can I use my old I-140 to get 3 years extension on my H1?
Yes, you can. The law currently is if your I-140 remains unrevoked, even though you have changed employers and you want to extend H1 for the second employer based upon the I-140 of the first employer, there is no problem. We do it all the time.
Okay.
Okay.
But this can be done only after 180 days, you think?
No, that is not the law at all. That is the new regulation. I'm giving you the current law. If you change employers and the I-140 remains unrevoked, it can be used to extend H1 through any employer. No problem.
Okay, I got it.
All
Thank
right.
you.
Good luck.
Yes, thanks.
You're welcome. Okay, let's go on to the next frequently asked question. PERM-based green card through relative-owned company. You cannot do a PERM usually for a family-owned company or family-controlled company. It's very difficult. If, however, we've done 3 or 4 cases over the last few years where this situation arose and we were able to get the cases processed, the normal trend of adjudications is that if the company is relatively large or the share of the relative is relatively lesser, or the relative can be isolated from the recruitment process and somebody else takes over the recruitment process completely, we can actually get green cards, PERM-based green cards approved through relative-owned company. That's one side. AC-21, on the other hand, if your I-140 is approved, 485 has been pending 180 days, can be easily done through a relative-owned or relative-controlled company. So I think it's a bad idea if you're going to try to get a PERM through a relative-owned company. Get it evaluated by a lawyer. Normally, these are long shots. AC-21, no problem. And just keep this in mind. Okay. *5 if you have a follow-up question on this. *5. Any follow-up questions on this? Okay, let's go on to the next frequently asked question. And this is another interesting situation. Um, this is about visa fraud. A couple of weeks ago, I suspected a company might have a problem, very small company. I suspected they might have a problem um, with visa fraud allegations. So actually, I got a criminal defense counsel involved, and I myself conducted a question by question, almost like a direct examination would happen in court or a cross examination would happen in court. Went over every single aspect of the transaction before, and of course, the criminal defense counsel was present in the room, or actually by conference call, um, to ensure that I wasn't missing anything, because I am familiar, conversant, very comfortable with immigration law, but my knowledge of criminal defense law is very limited. But I'm also a litigator, and that guy is an expert in criminal defense. So between the two of us, we spent close to, I don't know how many hours, going over all the issues. And this was, like I said, a small company. If it's a bigger company, the transactions can be much more complicated. So it's kind of difficult to make a determination, a snap judgment on how serious this issue is. Okay. Part of the problem is, if somebody in the company is getting indicted or under investigation, does it affect the entire company? Does it affect the employees of the company? Too many variables for me to comment. But is there a practical resolution? Let's look at your situation. Kritesh says, ABC company, I've been working for 6 years. Ex-CEO, who was the CEO from 2014 to 2015, is involved in a visa fraud case with his own company, XYZ. A criminal complaint was filed against him. He's no more a part of my company. Does it affect my company? See, that's a difficult question to answer until I have examined the people concerned. If we were to make a snap judgment, we would say that, well, unless he ran the company that you are a part of with a criminal conduct and in a criminal enterprise manner, we can understand how it could become a problem for people like you. But if your own company for which you work was being run cleanly, and really there's no issue of, just because somebody has committed some bad acts for their own company does not necessarily mean their entire professional life has been tainted. So I do not really know the answer to that question. Should you change your company immediately? I do not know the answer to that question. That is something we would need a lot more information about. Okay. Now, if you have your I-140 approval and the option exists to change the companies and start the green card all over again, I would certainly seriously consider it. I would also recommend that you do a consultation with a lawyer, go over the worst case scenario. And that's the way I look at it. I plan for the worst case. Okay, so company ABC with whom you are working now is also criminally culpable for some reason. What should you be doing? See, the thing is, USCIS, if they find fraud, can always go back and reopen the I-140s and revoke them. And if they revoke them, you get nothing. You don't get your priority date either. So keeping the worst case scenario in mind, it makes sense to start a green card through another company to have kind of a back pocket option. You may not need it, but it's nice to have it. But are you really in a position to easily do that? If you can, by all means do so. But are you being overly cautious, almost paranoid? Well, I think you should always plan for disaster, right? That's part of good planning. So any follow-up questions on this, Kritesh or somebody else, press star 5. Follow-up questions, press star 5. I remind you, I'm also watching my Twitter account. If somebody tweets to me, okay. Let's look at the next frequently asked question. I think I have one more. No, I don't. Okay. Let's start reviewing the questions in the order in which they were posted. I'm on L1B blanket visa. So one of the questions was, if I want to convert to L1A, do I need a 6-month kind of a cushion period? And the answer is yes, you do. Can premium processing help my situation? Let's see. L1 blanket, 5 years are getting over in October. October 13th. I think you're already too late for that 6-month period. So premium processing is not going to help you. If, however, you were qualified for L1A when you got the L1B, I don't see any problem in trying for L1A now. Okay? If they offer you a managerial level job, I think you can qualify for an L1A and get another extra couple of years. Why? Here's the difference in the situations. That regulation that requires the 6 months, and I'm speaking from memory. I could be wrong, but I think I'm right. The regulation that you talked about, the 6-month buffer, that regulation covers a situation where an individual is not qualified for an L1A because they had not worked as an executive or managerial employee while they were in the home country or a third country other than USA. They came on an L1B. Now we are promoting them to a manager level. We can get L1A conversion if we do it with 6 months to spare. But if somebody like you who already qualifies for L1A, I don't think you have that problem. I think you can go to L1A. I don't see any problem with that. Okay. So Divyendu, if you're on the phone, press *5. I want to address this issue first. Okay, good. You're here. Let's see. Yeah, Divyendu, did you get my point? I don't think this is a problem. You should be able to get L1A.
Good afternoon, Rajiv. Yes, Dipendu here. Thanks for this community service that you are
My pleasure.
running.
My pleasure.
Yeah, so I just wanted to confirm. My employers are telling that you are already late at this point and we can't process.
They are mistaken.
So I was just trying to confirm.
Dada, they are mistaken. They are mistaken because they are confusing the regulation with your situation, which is different than the regulation envisages. Regulation is for those people who don't qualify for L1A entering the United States. You were qualified when you entered. You just took L1B. I don't see any problem getting you an L1A.
No, actually, when I got my L1B about now at this point, close to 5 years back, at that point it was based on technical expertise only. But 3 years back, I was promoted, and since then I have been additionally also involved, apart from my core technical responsibilities, also in managerial capacity.
No, hang on.
Like what?
Hang on. That's a different situation. The 1 year of managerial experience has to be outside USA. Okay? If you are not relying upon that, and you're relying upon experience gained while in the United States, then you are stuck with the 6-month regulation.
Okay.
So then I agree with your company. They're right.
And is it like the managerial experience has to be like within 3 years of like myself applying for the conversion? Is that something like that?
No, the law is if you are not, let's rephrase this. If you already have L1A type executive experience before you entered the country and you came on L1B, we can convert you to L1A anytime, no 6-month period. If you gained your managerial experience after you entered the US, we have to go by the 6-month regulation. That's what I remember.
Okay, Raji.
Okay, so that's the way it
Okay.
works.
Okay.
So your question is, can I resign from my employer and continue my stay in USA till I-94 authorized date? No, because that I-94 is way beyond your 5 years period.
Okay.
Can I create an LLC and create my own business? No, there is no such provision. There's no such provision. Okay.
Okay.
Anything else I can help you with?
No, as of now, I'm good. Thank you.
Good luck, sir.
Thank you.
Okay, let's go on to the next question. This is a very complicated question, and I'm sorry, Immigration Help 2014. I'm not going to be able to answer your question. This requires some reading and some review of the regulations, and I just don't have all the information off the top of my head. Okay. Your questions were irrespective of whether future baby is born in USA or India. Do you see any other issues for me for removing conditions on my green card? Because you're on a conditional green card, but spouse is going to move. She's pregnant, okay. If the future baby is born in India, so one of the questions was about the baby's citizenship. I would say read the instructions on form N600 for that. Okay. Don't remember all the law off the top of my head, but there are certainly provisions for something like that. She is a US citizen, so there's no question about her background. That should not be a problem. Because she got her naturalization, I don't think that issue can be revisited. I hesitate to give you a clear answer that you should not have a problem with your conditional residence or conditional status removal. It's difficult for me to predict that. I don't see any obvious issues from the fact pattern that I see. One of the requirements, I don't know what exactly your concern is. I'm a little confused. I hope you are here. If you are here, press *5 on your phone. Let's spend a couple of minutes with you, see if we can resolve it. *5. Okay, I don't see what the issue here is. Read N600, but do consult with a lawyer about the conditional green card, because I don't see any problem. Obviously, you have something that concerns you, and because I don't see it, I would want somebody to take a look at your case carefully. Next question is Ragesh. Ragesh GR says, will I be eligible for H-1B exemption? So he's got his H-1B approved in 2012, resigned in 2013. Approval was revoked in 2014. Currently, I'm in USA in H-4. Am I H-1B quota exempt? I think you are. If you get your H-1 filed, I think it should be quota exempt. Revocation does not bother you because your H-1, once approved, was good till 2015. Even if we take the worst case scenario, you resigned in 2013. Up until December of 2013, you should be okay to apply for an H-1 under quota exemption. I don't see why not. *5 if you have a follow-up question on this. *5. Okay. Let's go to Apollo 123, who says H4 and H4 EAD. I have my H1B extension in premium coming up in September. Wife is F1 OPT till July 2017. We want to file for her concurrently with my H1B extension in premium. What would be a good option? We are expecting she might have to take leave sometime in late December. Wondering if we should look for that window. Company policy is to terminate you if your OPT is not valid. Manager may hire you. So we are looking for an option where no minimum gap in employment could be achieved. So basically what you're saying is, if somebody is on OPT, which is expiring in July 2017, of course, assuming that she can't get an extension, for example, a STEM extension, is there any way to ensure that there is no gap in the EADs from OPT to H4? And the answer is not really. Only thing you can do, the fastest you can make this case is, if you apply your H-1B premium, which you are planning, and start her H-4 premium as well. Now remember, these days on H-4, you can put a date specific when you want her H-4 to kick in. So you could ask for H-4 effective July and EAD also effective July. That I see as the only quick option for you. I don't see any other. *5 if you have a follow-up question on this. *5. Next question is James 3456. H-4 EAD with employer change. Currently, I'm on H-1B with an employer for the past 6 years. Based on my I-140, spouse got H-4 EAD expiring March 2018. If the previous employer revokes my I-140, what happens? I guess you talking about H-4 EAD. See, H-4 EAD, government has said they reserve the right to revoke an H-4 EAD. Whether they do it or not, we don't know. They reserve the right if there is no valid I-140. So if the I-140 is revoked, they reserve the right to revoke the H-4 EAD. Will they actually do it? We don't know. If my previous employer does not revoke the I-140, is my wife eligible for H-4 EAD renewal even though I did not get the I-140 approved from the new employer? The answer is yes. All we need is one I-140 that remains unrevoked, and whether it is with your current employer or 3 employers before this one, it doesn't matter. Your wife will be entitled to an H-4 EAD. *5 if you have a question. *5 a question on this. Okay, there is a question. Let's go back to that. James. Yeah, go ahead. New York, go ahead, please. New York.
Hi, Raju. I appreciate your community service. Thank you very much for that.
My pleasure.
So my question is here. Actually, I got this I-140 approved, and my spouse got this H-4 EAD until March 2018, right? So my concern here is, if the employer withdraws my, let's say if I move out of the employer to the new company, if my employer withdraws I-140, does USCIS immediately revoke it or by default, or what if USCIS revokes it? My H-4 EAD is still valid or not?
Well, the H-4 EAD is valid until revoked. So once again, until somebody comes in and revokes it, and they can only revoke it after giving you notice. Okay. Typically, the process for revocation of an EAD is they will send you a notice of intent to revoke, giving you probably 10 days to respond. And if they're not satisfied with your answer, they can revoke the EAD. Now, will they actually do it based upon revocation of an I-140? We don't know. I doubt it very much. I don't think they have that kind of will or organization to go back and revoke an H-4 EAD, but they certainly reserve the right to do so. Okay.
Okay. So to my understanding, I mean, they don't do it by default, right? So once the USCIS withdraws it, I mean, employer withdraws it, USCIS won't just send a letter to me to get some get the information from me, but it won't do it by default revoke.
There's no default revocation just because I-140 is revoked. No.
Okay.
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 All right.
Thank you very much.
You're welcome. Good luck. Okay, let's go on to the next question. So Vittorio has a problem with the lawyer who basically seems to have done a poor job of representing them in an H1 process. Can we sue the attorney for negligence or malpractice? Yes, you can. Look, malpractice suits are difficult. I am not going to advise you on what the legal action merits are, but suffices to say, and I can explain to you, unfortunately, it's unethical for me to comment about state law because this is a matter of state law, not federal law. Certainly talk with local lawyers if you think there's a malpractice action. But what you can do is, which is free of cost, doesn't cost you anything, is file a complaint with the bar. Okay, bar complaints uh, are definitely a matter of concern for any lawyer. You know, and especially if they're at fault, bars are very typically they're very tough on lawyers who don't perform their responsibility adequately, and then on top of that, they demand more money for doing something, which is because of their own wrongdoing. So I'm not sure what you are saying is merely your perception or the fact, because I don't know your lawyer side of the picture. But I'm assuming what you're saying is true. And please, I'm not trying to downplay or somehow put you down for this. I'm just making an observation from as impartial a perspective as I can manage. So I think filing a complaint, a bar complaint, is a very good idea. When you feel that you've been wronged, you shouldn't let it go. If a lawyer is a bad lawyer, if I'm a bad lawyer, I would want to know. Okay, I shouldn't be practicing law if I can't help people. There's many ways, many ways to make a living. You don't have to do something which is actually causing more harm than good. So yeah, by all means complain, but as far as a malpractice lawsuit, you'll have to talk to the local lawyer what the feasibility of that is. Don't be surprised if they tell you that's a long shot. Okay, star 5, Vittorio, if you're here, you have a question, star 5. Okay, let's go on to the next question. Immigration question says, while filing H-1B, end client letter is not available. Guys, generally speaking, if you don't have an end client letter or sufficient documentation that establishes the information that government wants from the end client letter, such as a work order or something similar like a contract between the end client and the prime vendor, it's difficult to get these cases approved. Not impossible, but extremely difficult. So end client letter is not available, but vendor can give a letter. That usually doesn't help. Unless the vendor is in control of the entire project, usually a letter from the vendor is not enough. Okay. If the end client gives a letter for 6 months stating that project may be long term, can I get petition approval for longer than 6 months? It's possible, because remember, we don't have to prove beyond reasonable doubt any of the USCIS questions. We have to only prove that it is 51% likely and 49% unlikely that this will happen. That's called 10. I forgot the standard of proof that is called. There is beyond reasonable doubt, which is criminal evidence burden, a preponderance of the evidence. Then there's clear and convincing, which is a little bit less than beyond reasonable doubt. And the least burdensome proof is preponderance of the evidence, which means it is more likely than not that your project will get extended. It doesn't have to be foolproof, just more likely than not. And I would say a statement from the end client that the project is likely to continue could help. I can't guarantee it will work out, but it could help. Okay. Star 5 if you have a question. Star 5. Okay. Bushali says, I'm on F1. Oh, there's a question. Let's go back. This is no new question. Ohio, no new questions, only a follow-up on what I discussed. If you have a new question, put your hand down. Star 5 again. We'll deal with new questions, time permitting. But right now, we are just dealing with the posted questions. No new question, guys. Okay, I'm assuming there are 2 hands that are up. I'm assuming that you both have follow-up questions on what I just discussed. Let's go to Illinois first. They logged in first. Illinois, go ahead. Illinois. Okay, Illinois is not talking to me. Oh, both hands went down. Obviously, you guys were mistaken. So if I have time, I'll get to Illinois and Ohio both. Oh, Ohio still has a question. Okay. Ohio, go ahead. Ohio.
Hello.
Yes.
Yeah. Hello.
Yes, ma'am.
Yeah, I'm Renuka. Yeah, my question is like my husband filed a divorce case.
Ma'am, stop right here. Stop right here. I have said it 3 times or 4 times. No new questions. I'm only dealing with posted questions. Wait till the end of the call. If we have time, we'll deal with, So I'm gonna put you back on mute. Okay. So Renukaji, if I have time, we'll deal with your question. But I specifically said only follow-up questions, no new questions. Next question is from Vishali, who says, I'm on F1 visa working on OPT, which is expiring 3rd May. H-1B has been filed. So my OPT is valid. I can work till June 1st. No, you can, if you are selected in the lottery, you can work all the way to October 1st. If you are not selected in the lottery, just read up on cap gap extension. There are certain things that you need to be aware of. Just do a search on cap gap extension. Okay. And there is no automatic extension, even cap gap extension. You have to go back to school and they'll issue you a cap gap I-20 with the proper endorsements. So before July, contact your school. No, I'm sorry, before May, which is right now. So contact your school and they probably would require some proof of the H-1 filing. They should be able to issue you a cap gap I-20, which will allow you to work. Okay. Star 5 if you have a question on this issue. No new questions. Star 5. Okay. Sunil Krimi has a question. Company A did EB3. The priority date 2008 was ported to Company B for EB2. Company B filed I-140 and 485 concurrently. So the case is awaiting review. Is it possible that due to concurrent filing, they did not update the I-485 to be EB2? It is possible, but unlikely. If you have any doubts about that, you can try to keep following up, including sending a letter in. You have opened a service request. How about you also try through your congressman's office? Okay, because the congressman's inquiry could probably get you a little bit more information. Delays in 485 can be random. They can last quite a bit. Difficult for me to say what the problem is. But non-conversion of the case is unlikely because they are all database oriented. So one query should be able to reveal what your earliest I-140 approval date is and what your latest I-140 approval is. I would say, yeah, you can try InfoPass also. If your suspicion is that they have messed up your paperwork, you can contact a congressman. Go take your InfoPass, do that first, because they have the screen in front of them. They can probably give you more information on what your case is doing. And if you're not convinced, go ahead and contact your congressman's office. *5 if you have a question. *5. No new questions, just a follow-up. Okay. Sandeep Agarwal says, I overstayed in USA 13 years back. Do I need police clearance from USA? Arunji, I don't, Sandeepji, I don't know the answer to this question because many times I'm not involved in this level of mechanical detail. Team members take care of that. My guess is, and this should be very easily verifiable online, my guess is that the FBI report covers the USA stay. But let me just double check if I can. Samanji, very quickly, if I have lived in USA for a couple of years, then I go back to India, and when my green card comes through, do I have to get police verification from or police clearance from USA also, or does the FBI cover that? Yeah, I thought so too. Okay, thank you. Yeah, I'm being told that FBI should cover that. We've never done it in the past in situations like this. So you don't really have to do anything except fill out the forms. Confirm it, please verify it. This is to the best of our information. *5 if you have a follow-up questions, please. Any follow-up question on this? *5. Okay. No follow-up question. Let's go to the next question. Ask341 says, I lost my job with employer A. My last day of work was Feb 15th on H-1B. Oh, don't do that, guys. You please be alert. No, I'm in the middle of the next question and now you raise your hand. Yeah, go ahead, New York. Go ahead, please.
Oh, sorry, I have a new question.
No new question. Sit tight. Okay. Sorry, guys. Okay, so going back to lost my job, last working day was 15th of 2016, Feb 15th. They may withdraw my I-140. I sent an application change of status to B2 on Feb 16th. You know, I think we did a very detailed conference on this yesterday. We did a very detailed consultation. I asked you to wait until I posted that. We had a 45-minute discussion on this issue only yesterday. And the title for that is Unlawful Presence, Status, Visa, Laid Off, Nunc-Pro-Tunc, all of these issues we discussed. Okay, so bottom line is unlawful presence begins from the date your I-140, your H-1 is revoked, probably. For sure, when your I-94 expires, that we know.
This is not a valid menu option.
1 second. One second, guys. Don't know what it's talking about. The system just beeped at me. Okay, so the fact that you applied on Feb 16th for tourist status also is not a happy event. You should apply before your status goes away. Okay, but like I said, I have dealt with this issue in great detail. We analyzed the heck out of this issue yesterday. That will be a separate recording, and I'll post a link on that to that recording also. So I'm not going to address this issue, and I'm pretty sure you're not here. If you are, press *5 because we dealt with this issue yesterday. *5? No. Okay, I didn't think so. Then we have an issue about a friend came to the US when they were 12. High school was done, received a diploma, went back to Columbia in 2010. Um, while he was in the USA, he had a green card. Well, that green card is gone because he's been gone so long. As far as I know, that green card cannot come back. Okay. Star 5 if you have a follow-up question. Yeah, you've been outside USA for several years. The green card is gone. Very rarely can you recapture it, even if you're a minor, as far as I understand it. Rahul K has an L1A visa since September 2015. EB3 PERM is being filed. How do I extend my stay? You should convert to H-1B and you will be subject to the cap. And that's the only option I know. Of course, if you qualify for, hang on, what am I saying? You came on L1A. Why didn't you do an EB1C? Rahul, are you here? Star 5, please. Star 5. Okay, you're not here. I don't understand this. EB1C should have been done. Within a year, you've got your green card. You are on L1A. Why did they even go through the hassle of a PERM? That doesn't make any sense. Something is not sitting well here. So please confirm with your lawyers. Why did they not do an EB1C instead of doing an EB3? Okay. Let's go on to the next question. This is for continuous residency for US citizenship. They have been green card holders for 5 years, but they've been in and out a few times. 1 year, they were gone 10.5 months? Or did you stay 10.5 months? Or you were gone about a month and a half? So I'm assuming this is what you are saying, that you were only gone that much time. Yeah, the first trip became longer than anticipated. May through June, that's less than 1 month. No, this is not a problem at all. See, I worry if in any 12-month period, you have more than 6 months outside USA. That's when I worry. Or if you have a consistent repetitive pattern of being outside for 5 months and 20 days, 5 months and 10 days. But in your case, it's a very sporadic, less than a month and a half, a year. That's what I'm reading. If that's indeed true, I'm not worried about it at all. It doesn't look like a problem. Star 5 if you're here. Star 5. I guess you're not. Now, your husband had to take a job to provide money. I think what you're saying is you were gone for 10.5 months. Maybe that's what you're saying. I can't really tell. It's a very confusing narrative. Look, if you have been gone for 10.5 months in 12-month period, you will be asked to explain, and you will have to explain adequately that you never abandoned your intention to stay in the US, especially if your husband took a job abroad. As long as you can prove that you always wanted to come back, you should be okay. But please, I would advise you do a consultation with a lawyer, go over your entire fact history. Make sure, because sometimes you go for a naturalization, you end up losing your green card. That happens to people. Okay. So this is a serious issue. I don't want to make a snap judgment. I think you should do a consultation. Make sure your background is okay. Because I can't really tell what you're saying. I think you're saying you were gone 10.5 months. Previously, I thought you were gone only a month and a half. So I can't really tell what you're saying. Okay. I think you're saying you were gone 10.5 months. I can't really advise you beyond that. This is a serious issue and it's very fact bound. Somebody should go over all your facts. Let's go on to the next question. Any follow up on this? Star 5. Okay. Last 2 questions, guys, and then we'll have time for new questions. There was a certain end of a project Sai Karthik says. Oh, I think, yeah. We did a consultation yesterday on your case. Sai had actually approached me for a consultation. So we've already dealt with this issue. I don't want to comment about this. Last question is Sri Chaitanya. Sai, if you're on the call, press *5 if you have a follow-up. Yeah, I answered all your questions yesterday. Okay. Then we come to Sri Chaitanya. Checked for my OPT process. Bank not accepted the check, rejected due to no check acceptance option was enabled by me in the past. So there was a problem in the filing fees. The check was bounced, let's say. You received a notice from Burlington Finance Center and you did a payment. But USCIS is still saying that payment was not done. You've called both the finance center of the USCIS and USCIS itself, and they just keep bouncing you around. I think you should contact your congressman's office. When you have this multi-agency or intra-agency problem, various departments are bouncing you around. In my experience, congressmen are very, very effective because government tends to straighten out its internal issues quite quickly when they know that somebody else is watching them. *5 if you have a follow-up question. *5. Okay, any new questions? *5, folks. Any new questions? *5. 1, 2, 3. Okay, please raise your hand now. Once I've counted, that will be it. We won't do new questions after that. Folks, there's a lot of you on here still. 4. Okay. 4 questions. 4 people have raised their hands. Anybody who's not raised their hand beyond this 4 will be done. Okay, it's locked. Let's start with the person who called in first. Oklahoma, go ahead, please. Oklahoma.
Hi. Thank you for having this conference call.
My pleasure.
I have a couple of questions. My first question is, once my 485 is approved, can I immediately change my employer?
I have a very detailed, frequently asked question on this. I'll give you the short version of it because the discussion I have on that video as well as frequently asked question is much more comprehensive.
Okay.
When does this become an issue? This becomes an issue at the time of naturalization. Okay. When you go for naturalization 5 years down the line, they can say, oh, you said you were going to stay with this employer and you moved that quickly. And the answer to that is twofold. First of all, on the date you got the green card approval, you had the intention to remain there permanently. Permanently doesn't mean forever. It simply means indefinitely. So on the date you got the green card approval, everything in your life points to the fact that you wanted to stay there indefinitely. If 2 days later you got a great job offer and you want to move, that's okay. Okay. So that's the number one thing to remember. Number two thing I would argue for you is this. Since the advent of AC-21, which allows me to change jobs after 180 days of 485 pendency anyway, why is this issue even an issue? Okay. So
right.
I think this has become quite diluted, but I don't want to challenge it. I would recommend that you have the intention to stay there indefinitely, and then actually, let's put it this way. Let's have you consult a lawyer before you make plans. You can certainly do it, but do it right. Okay?
Okay. Okay.
What is the next question?
And my next question is, so I recently filed for my H-1 extension and it was approved like 1 or 2 weeks back.
Okay.
Now I want to file for an H-1 amendment.
You want to
risk, or can I do that?
You want to file an H-1 amendment, ma'am? Is that what you said?
Yes.
No problem. I don't see any risk in that. We have had cases. In fact, recently I got a case approved where we filed for an extension. While the extension was pending, the project went away. So we had to file an amendment to another project. We had to file an amendment to another project. While that amendment was pending, that project went away and we had to amend to a third project. Remember, all of this is pending.
Oh.
So even there we got the approval. So
Okay.
yeah, it's not.
Okay.
I'm not concerned.
We filed.
One thing I want to add: as long as you acted in good faith, as long as, for example, sometimes companies might think that this is okay to do, but it's not. They might say, oh, we have an in-house project, but they really don't. And they get the H1 approval, and 3 days later they find a client, they say, okay, now go work there, we'll file amendment. That is wrong. That's a problem. But if your case is otherwise straightforward and none of this is there, I don't see any problem in filing a quick amendment.
Yeah, I think it is straightforward.
Good.
Yeah.
Good.
And can I file for an H1 amendment on a premium?
Yes, you can.
Okay, and my spouse's H4 won't get affected with amendments, correct?
No, no. You don't have to apply for an H4 as long as the H4 is valid. You may do as many amendments or as many transfers or extensions as you like.
Okay.
Okay.
Okay. That should be it. Thank you very much.
You're welcome. Good luck. Okay, let's go on to New York. New York, go ahead, please. New York.
Hi, Rajiv. Thanks for taking the call.
My pleasure.
I have a follow-up on one of the questions you discussed before.
Okay.
That is, if my employer has withdrawn my I-140, does the USCIS revoke it, or they don't do anything?
Revoke it. When you say it, you mean revoke the I-140?
Yeah.
Okay. When an employer sends a letter to the USCIS that we want to revoke the I-140, they do revoke it. Okay.
No, I mean, like, they can withdraw the I-140, right?
Well, it's the same. See, the thing is, I've always been a little concerned with this nomenclature, with the way we name things. I think withdrawal, in my mind at least, I don't think there's a real legal definition for it. Withdrawal is when the I-140 is not yet approved. It's still pending. Once it is approved, I think what we will do is we'll ask for a revocation. But I could be wrong about this. But let's just go with this nomenclature. Net effect is the same. When the employer says, I want to cancel this I-140, they'll cancel. Okay.
Okay.
Anything else?
Thank you.
You done?
No, that's it. Thank you.
You're welcome.
Yeah.
Folks who are logging in now, I will not be taking new questions. I see a couple of people just logged in. I won't be taking new questions. Sorry. Already I have a queue for questions. Okay. Ohio, go ahead, please. Ohio.
Hi, I'm Renka. Thanks for joining call.
Yes, ma'am.
My question is like, I'm on H-4 EAD.
Yes, ma'am.
Me and my husband working on the same company. So we both are in a divorce situation. So is there any chance for my husband to revoke my H-4 EAD?
Let me understand.
I mean, he can, he can apply for USCIS to revoke my H-4 EAD. It was, it will be until 2019.
Okay, ma'am, let's see if I understand your question. What you're saying is, I have an H4 and an H4 EAD. If I have a falling out with my husband, can he revoke my EAD? That's your question, right?
Yes.
Okay. And the answer to that is probably. How and why? Okay. If there is a divorce, automatically you are not entitled to H4. If you are not entitled to H4, you are then also not entitled to EAD. So divorce could be one way to do it. Second way to do it could be if he himself changes status to F1 or gets his green card. Okay. Can he request USCIS to cancel your H4? I think that would be difficult without a divorce.
Okay. My question is like, if he start, it's like from past 1 month it's going on. we were in legal notice situation. Like if he can start paperwork by applying legal things. So is it from that point my H4 will affected, or at the end of the divorce case it will be affected?
Do me one favor. Make sure that you have filed an AR11. Do you know what an AR11 is, Renukaji? Renukaji?
No.
Okay.
No, he haven't filed anything.
No, I don't care about him. Right now, hang on. Listen to me. I'm not talking about him. I'm talking about you. You need to file a form AR11. Write that down, please. A as in apple.
No.
Ma'am, I'm not asking you a question. I'm telling you something. Write it down. You need to file an AR11.
Okay.
What is AR11? AR11 is a form that you can file online. If you just search for it on any search engine, it should pull up right away. You can actually file it online. It tells USCIS what your current address is. You are required to file that form within 10 days of change of address. Okay. So make sure you are.
One more.
Go ahead.
One more question. Is there any chance for actually I did my master's.
Ma'am, I'm not done with my I'm not done with my comment. Please wait. So make sure make sure you have your most recent address always updated. Why? Because if USCIS wants to revoke your EAD, they should send you a notice. And they can only send you a notice if they know your address. Okay. So this is not a foolproof, but a good way to ensure that USCIS at least informs you before they take any negative action against you. So please update your AR11 and keep it updated. Go ahead with the next question.
I did my master's here. I've used 8 months of OPT. Then after I switched, my husband asked me to switch to H-4 EAD. Now I'm H-4 EAD. Is there any chance for me to go back, use my OPT, then I can file for H1?
I don't think that is a possibility. Are you a STEM graduate?
Yes.
You might be able to get an extension, a 2-year extension on your OPT. Look at the regulations, discuss them with your school. I think they will allow you to get 2 more years of extension of your OPT. Double check that. I don't remember the new regulations off the top of my head, but that is a more reasonable option. You can't recapture the 4 months remaining.
Okay. Then do I need to switch back to OPT? I called my.
Actually, I'm sorry. That may not be possible because you went to H4. Discuss it with your school, Renukaji. I don't remember all the regulations off the top of my head.
Okay, so if I go back to school again, then I can use my OPT?
Look, you might be able to get CPT, but can you get OPT? OPT you don't get till the school, the course is over. So let's look at the 3 possibilities. 1, you can get STEM extension. I have my doubt about that because you converted to H4, but check with the school. I don't know the law off the top of my head. 1 second. Guys, I will not be doing any new questions. People who had questions are already lined up. So no new questions. I know more people are joining in at this time. No new questions, sorry. Okay, so Renuka, check with the school if STEM extension is possible. That's number 1 option. Number 2 option is check with the school. If you go back to school, would CPT be an option? Curricular practical training. Okay, those 2 are the clear-cut possibilities that I see. What else?
Okay. So there is no way for me to, without joining school, there is no way for me I can use my OPT, right?
You cannot use your OPT that is 4 months remaining. That's gone. Can you get an OPT extension under the new regulations? Doesn't hurt to check. Can you go back to school, go back to F1 status and get CPT? Probably. All right?
Okay. Well, yeah.
Good luck, ma'am.
So
I'm gonna have to. I'm
picking
gonna have to. At some point, I'm gonna have to say that's enough. I'll let you ask one more question, but make it very quick, please.
Okay. So my driver license also got expired. So is that something I can through legal I have to go through, or
That's a state law issue, ma'am. Every state has its own little quirks on
Okay.
how they deal with driver's licenses.
yeah.
Not much I know about that. Sorry. Okay.
Yeah. Thanks,
Good.
Rajesh.
Oh, you're
Thanks
welcome.
so much.
You're
Thanks for your time.
You're welcome. Good luck. Sorry, I'm just tired towards this time. It's it's been a long day. We had a very, very busy morning. Okay, let's go back to the last question now, and this is from Illinois. Illinois, go ahead, please. You're on the phone. Go ahead, please. Illinois. Illinois. Chicago. Area code 312. We can hear you. Hello. Okay. Well, folks, it's been great talking with you. I always enjoy it. We'll see you again in 2 weeks. Thank you for your time. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.